Welcome to the Deep Dive. Today we're taking an in-depth look at a really vital part of criminal law, the definition and elements of the offense of rape, specifically under the Sexual Offenses Act 2003, the SOA 2003.
Yeah, that's right.
And we really want to give a huge thanks to the University of London for making the source materials for this deep dive available to students. These conversations are built on resources like those, and they're purely for educational purposes.
Absolutely.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. For all of you studying this area, especially those, getting ready for your exams, good luck.
Yes, good luck. Our goal here really is to navigate the key legal concepts, the procedural steps, and the important cases that define rape in England and Wales today. Understanding this area is just fundamental.
So we'll aim to highlight the core principles you really need to grasp. We're going to break down the conduct elements, that's the actus reus, and the mental requirements, the mens rea. But as you'll see, the real heart of most cases, and where the complexity often lies, is, well, the issue of consent.
Definitely.
We'll spend the bulk of our time unpacking how the SOA 2003 deals with consent, using those statutory presumptions under Section 76, that's the conclusive one,
Right.
and 75, the evidential one, and then the general statutory definition in Section 74.
And mastering that procedural flow, thinking S.76, then .75, then S.74 is absolutely non-negotiable for tackling problems in this area. You just have to get that order right.
Okay, let's unpack this then. Let's start with the actus reus, the physical conduct required for the offense of rape under Section 1 of the SOA 2003. What's the defining act?
The essential actus reus is the non-consensual penetration of the vagina, anus, or mouth of another person by a man's penis.
So penetration by a man's penis is the critical defining feature.
Precisely. That's key. If the penetration is with fingers or a tongue or an object, say a bottle or even a sex toy, that's not rape under Section 1. It could still be a very serious sexual offense, mind you, potentially sexual assault by penetration under Section 2 for vagina or anus, or sexual assault maybe for the mouth, but it's not rape as defined by this specific section.
Got it. Penile penetration only. What about the concept of penetration itself? Does it have to be like a complete act or sustained?
Ah, good question. The Act clarifies this in Section 79.2. It defines penetration as a continuing act from entry to withdrawal.
A continuing act.
Yes, and this is a really important detail. It actually formalized a principle that came from an older case, Kaitamaki, back in 1985.
Taikamaki. Right, and the continuing act idea. So what's the significance of that?
Well, the significance is this. If a man begins intercourse with consent, but during the act, consent is clearly withdrawn. Maybe the person says stop or makes it clear they no longer agree.
Right.
And he continues the penetration. He commits the actus reus of rape from the point consent ended because the penetration is continuing without it.
Ah, right. So consent isn't just a one-time thing at the start. It has to be ongoing and can be withdrawn.
Exactly. That's crucial.
And who can commit rape?
Right.
And who can be the victim?
Okay, so rape can only be committed by a man. That's specific to Section 1. But the victim can be either a man or a woman.
Right. And is ejaculation necessary?
No, explicitly not. Section 1 doesn't require ejaculation for the offense to be complete. That was confirmed relatively recently in R on the application of FVDPP in 2013.
And just to cover all bases, what about surgically constructed vaginas?
Section 79.3 makes it very clear that vagina includes those after gender reassignment surgery. The law is inclusive there.
Good. And it seems almost unbelievable now, but historically there was a point where a man couldn't rape his wife.
Sadly, yes, that was the law for a very, very long time, this so-called marital rape exemption. But thankfully, that changed definitively in 1992.
Right.
So since then, rape is possible between a man and his wife. A wife's consent is absolutely not presumed just because they are married. She has exactly the same rights and protections as any other person under the SOA 2003.
Okay, so that covers the actus reus side pretty well. Penetration by a man's penis, non-consensual, it's a continuing act. We know who can be involved. Now, you mentioned that the absence of consent is usually the biggest hurdle. Why is that?
Well, it's largely because these acts typically happen in private. There are rarely independent witnesses, so it often comes down to the victim's word against the defendant's.
Right, one person's account versus another's.
Exactly. And historically, this made proving lack of consent incredibly difficult for the prosecution. And unfortunately, it often led to really unfair and intrusive questioning of victims, essentially putting them on trial, questioning their character, their sexual history. It
Yeah.
was awful.
That sounds incredibly damaging, and the SOA 2003 tried to address that, at least in part.
Yes, it aimed to. One way was by introducing these mechanisms, particularly these statutory presumptions, to try and, well, simplify proving lack of consent in certain clear-cut situations.
Okay.
And this is precisely why understanding sections 76, 75, and 74, and importantly, the order you consider them, is so vital for students.
All right, let's nail that procedure down then. How do you approach consent when you're looking at a scenario, say in an exam?
You always start with the most powerful tool the Act provides, the conclusive presumptions under Section 76. Always check S.76 first.
Section 76, conclusive.
Yes. If the prosecution can prove one of their specific circumstances beyond reasonable doubt, the issue of consent, and crucially, whether the defendant reasonably believed there was consent, is decided immediately. It's conclusively presumed absent.
Conclusively, meaning no argument from the defense on that point.
Correct. If S.76 applies and is proven, the defense cannot argue consent or reasonable belief in consent. End of story on that issue.
Okay. And if S.76 doesn't apply, or the prosecution can't prove it?
Then and only then do you move to Section 75, the evidential presumptions.
Evidential. So this one can be argued against. There's a bit more leeway.
Exactly. If a S.75 circumstance is proven, it presumes lack of consent and lack of reasonable belief. But, and this is the crucial difference from S.76, the defense can offer plausible evidence to rebut that presumption. It raises the issue, but it's not necessarily the end of the story.
Right. And if neither S.76 or S.75 apply, or if S.75 presumption is successfully rebutted.
Only then do you fall back on the general definition of consent in Section 74. You then have to assess whether the prosecution has proven absence of consent based on all the evidence using that S.74 definition.
So the flowchart is crystal clear. S.76 first. If no, then S.75. And if no, or if S.75 is rebutted, only then S.74.
Got it. Let's dive into S.76, the conclusive ones. What are the two specific circumstances there?
Okay, Section 762 gives us two grounds. First, subsection A, where the defendant intentionally deceived the complainant as to the nature or purpose of the relevant act.
Deception about the nature or purpose. What does that look like in practice? Can you give an example?
Yeah, a classic case, even from before the SOA 2003, is Williams from way back in 1923.
Williams, okay. A singing teacher told his student that having intercourse with him was actually a necessary surgical procedure to improve her singing voice.
Wow, okay.
So she consented, but she consented to what she thought was a medical treatment, not a sexual act. The court held that this deception totally vitiated her consent. It was consent to something fundamentally different in nature.
So deceiving someone about what they're actually agreeing to do, how is that different from, say, deceiving them about something else related to the act, maybe like getting paid for it?
That brings up the case of Lineker from 1995. There, a defendant tricked a prostitute out of her payment after they'd had sex.
Right.
The court said that wasn't deception as to the nature or quality of the act itself. She had consented to and received the sexual intercourse she agreed to. The deception was about payment, not the act.
Well, you mentioned the SOA 2003 includes deception as to purpose as well as nature. Could Lineker be different now?
Well, that's an interesting point raised in the source material. Could her purpose in agreeing be seen as payment, and was that purpose deceived? It's arguable, perhaps. It shows the nuances.
And didn't Cheated in 2007 say this S.76 presumption needs stringent scrutiny?
Yes, exactly. Because it's conclusive, it basically removes the defense's ability to argue consent, so the courts are, quite rightly, very careful about applying it. It has to be a clear case of deception about the fundamental nature or the core purpose of the act itself.
So think about that Newland case mentioned in Activity 8.1 in the materials deception about gender identity. Does that go to the nature or purpose of the sexual act? It really forces you to scrutinize what those terms mean.
It does. It's not always straightforward.
Okay, what's the second conclusive presumption under S.76? That's subsection B, right?
Yes, S.762. That's where the defendant intentionally induced the complainant to consent by impersonating a person known personally to the complainant.
Impersonating someone the victim actually knows personally.
Exactly. Key phrase. Known personally. The act expanded on the previous law, which often only covered spouses or partners. You might remember the Elba K case from 1994.
Vaguely. Twin brother?
That's the one. A twin brother impersonated the victim's boyfriend. Under the old law, that counted. Now, Under the SOA 2003, it's broadened to any person known personally.
So pretending to be their neighbor, their friend, maybe even a family member they know.
Yes, as long as the victim knows that specific person personally. But, and this is crucial, they must be known personally. Look at illustration 8.1 in the source, the Brad Potts example.
Right. Impersonating a famous film star. Even if the victim is completely tricked and, wouldn't have consented for a second if they knew the truth.
It doesn't trigger the conclusive presumption under S.762. Why? Because Brad Potts, the film star, wasn't a person known personally to that victim.
Oh, wow.
So the prosecution couldn't rely on S.76 there. They'd have to fall back to Section 74 and argue that the deception negated consent because it meant she didn't agree by free choice.
That really clarifies the very specific scope of S.76 then. If one of those two things, deception as to nature purpose or impersonating someone known personally, is proven beyond reasonable doubt, the prosecution wins on the issue of consent. No debate.
Correct. It's a powerful tool, but only in those specific situations. If not, or if it can't be proven, then we move down the ladder to Section 75.
Section 75, the evidential presumptions. So these create a presumption that can be rebutted by the defense. What kind of circumstances trigger these? Where consent is maybe highly unlikely, but not absolutely impossible.
That's a good way to put it. Section 75.3 lists 6 specific scenarios. Let's run through them quickly. A. Violence was used or feared against the complainant. B. Violence was feared against another person. C. The complainant was unlawfully detained, and the defendant wasn't. D. The complainant was asleep or otherwise unconscious. E. The complainant had a physical disability that prevented them from communicating consent. F. And this is a common one. A substance was administered without the complainant's consent that was capable of stupefying or overpowering them.
Okay, so these cover situations where someone's clearly coerced or incapacitated or just unable to resist or communicate effectively.
Yes. If the prosecution proves one of these circumstances beyond reasonable doubt, the law then presumes 2 things. First, that the complainant did not consent, and second, that the defendant did not reasonably believe they consented.
But the defense gets a chance to push back.
They do. The defendant is given the opportunity to offer plausible evidence. It has to be plausible, not just a denial, to show that despite these circumstances, there was, in fact, consent, or at least that they reasonably believed there was.
Like the example given in the source material about a couple who allegedly sometimes have consensual sex while one is asleep. That might be offered as plausible evidence to try and rebut the S.75 presumption if the victim was asleep.
Exactly. That's the kind of scenario where rebuttal might be attempted, or with the date, rape, drugs scenario under S.753.
Right.
The prosecution only needs to prove the substance was administered without consent and was capable of stupefying. They don't actually have to prove it did overpower the victim.
Okay.
The defendant could still try to rebut the presumption by arguing, for example, that the victim seemed fine and was actively consenting even if they'd been drugged.
So if the prosecution proves a S.75 circumstance, the presumption kicks in. But if the defense offers plausible evidence to rebut it, what happens then? Does the presumption just disappear?
Effectively, yes. The burden shifts back entirely to the prosecution. They can no longer rely on that S.75 presumption to help prove their case.
Okay.
They must now prove, based on all the evidence presented by both sides, that the victim did not consent according to the general definition in Section 74, and that the defendant did not have a reasonable belief in consent. They have to prove both elements from scratch, essentially.
Let's use illustration 8.2, the spiked drink example from the source, to walk through that S.75 to S.74 flow. It seems really important to get that sequence.
Okay, good idea. Illustration 8.2, Donald spikes Yvonne's drink with alcohol, which is certainly capable of stupefying. The prosecution proves this happened without her consent. That triggers the S.75 presumption.
So the starting point is presumed no consent, presumed no reasonable belief by Donald.
Correct. Now, what if Donald says, well, Yvonne was laughing and flirting with me earlier. She invited me back. She seemed totally fine. I thought she was completely willing.
Could that be plausible evidence to rebut?
It might be. The judge would decide if it's plausible enough to leave to the jury. If the judge decides it is plausible evidence capable of rebutting the presumption, then the presumption falls away.
Okay, so the presumption's gone. Now what?
Now, the prosecution has to prove their case under the general rules using Section 74. They would argue that someone who has been involuntarily drugged, even if they appeared outwardly okay to Donald, couldn't actually exercise a free choice as required by Section 74. Their capacity or freedom to choose was compromised by the drug he gave her.
And what about Donald's belief? He claimed he thought she was consenting.
The prosecution would argue his belief couldn't have been reasonable. Why? Because he knew he'd spiked her drink. How could he reasonably believe she was freely consenting when he knew she was under the influence of a substance he'd secretly administered?
That makes sense. And as the case Ciccarelli from 1011 shows, the judge can actually step in regarding the reasonableness of belief, can't they?
Yes, absolutely. Even if the defendant claims they believe there was consent, if the judge looks at all the evidence and thinks there's simply no basis upon which a reasonable person in the defendant's shoes could have held that belief, like in the spiked drink example, where the defendant knew they administered the substance, the judge can potentially withdraw that issue from the jury or give a very strong direction.
So a belief has to have some grounding in reality.
Exactly. A completely irrational or delusional belief, like in the B case from 2013 where the defendant believed sex had healing powers, well, that's by definition unreasonable.
Okay, that procedural flow was S.76 first, then S.75, then maybe back to S.74, and the reasonable belief test is absolutely key. Let's just quickly run through those scenarios in Activity 8.2 using this logic. First, Donald and Vera. Money promised but not paid.
Right. Not S.76. It's not deception about the nature or purpose of sex itself, arguably, and no impersonation. Not any of the S.75 circumstances listed. So consent would have to be assessed purely under S.74. Was her agreement a free choice? Debatable maybe, but no presumption helps the prosecution here.
Okay, Donald and Wendy, impersonating the famous actor George Clouzot.
Like the Brad Potts example, George Clouzot isn't known personally to Wendy, so not S.762. It falls back to S.74. Was it a free choice given the significant deception about who he was? That's the S.74 question.
Right. Donald and Beatrice, the twin brother, impersonating the Facebook friend Frank.
Now Frank is known personally to Beatrice, even if just online initially, perhaps. This looks like it fits squarely within S.762b. If the prosecution thinks that impersonation intentionally induced consent, then consent is conclusively presumed absent. Case likely won on consent.
Okay, clear difference. Donald and Xenia, intercourse with his waking spouse.
Xenia was asleep initially when penetration began. That clearly triggers the S.2503 evidential presumption. No consent, no reasonable belief presumed. Donald could potentially offer plausible evidence to rebut maybe evidence of a pattern of consensual sleeping sex, however difficult that might be. If he successfully rebuts, it goes back to S.74. If not, the presumption helps the prosecution.
Donald and Yvonne, the spiked drink at the bar.
We just went through this one. It triggers the S.75 evidential presumption because he gave her a substance capable of stupefying without her consent. He can try to rebut, but it likely goes back to S.74, where the prosecution argues no free choice and, crucially, that his belief couldn't be reasonable given he spiked the drink.
Makes sense. And finally, Donald and Violet, the handcuffs and the threat. We are going to have sex now.
This scenario screams fear of immediate violence, which engages S.753, possibly also unlawful detention under S.753C if she felt she couldn't leave because of the handcuffs or threat. So, S.75 evidential presumptions apply. Donald could try to rebut, maybe claiming it was consensual BDSM roleplay, a fetish scenario. If he fails, the presumptions stand. If he offers plausible rebuttal, it goes back to S.74. Did she agree by free choice, given the threat and circumstances? Likely not.
So that brings us neatly to Section 74 itself, the definition that applies when the presumptions don't decide the case. What does S.74 actually say consent is?
Section 74 states, quite simply, a person consents if he agrees by choice and has the freedom and capacity to make that choice.
Agrees by choice and has the freedom and capacity to make that choice.
Yeah.
Okay. On the surface, that sounds reasonably clear. But you mentioned earlier the source points out it's sometimes criticized as being a bit loose.
It is, yes. Before the 2003 Act, consent was notoriously difficult to define legally. Juries were often just told to use their good sense, as established in the case of Old Boja back in 1982, distinguishing real consent from mere submission.
Right.
And while S.Con 74 now provides a statutory definition, terms like freedom and capacity are inherently quite broad and open to interpretation. How much freedom is enough? What level of impairment removes capacity? The quote from Temkin and Ashworth in the source material reflects this ongoing ambiguity. It leaves a lot to be interpreted case by case.
And it seems the old idea, maybe lingering from before the act, that reluctant agreement, or maybe agreeing out of a sense of duty perhaps to a long-term partner, like in the Mohammed Safar direction that was approved in the Doyle case, 2010, might still be seen as consent under S.74, even if it doesn't feel like genuine, enthusiastic, free consent.
That distinction between real consent and mere submission from Olugboja does seem to persist, yes, in how Section 74 is sometimes applied. However, other cases like Kirk from 2008 involving a homeless woman having sex for a small amount of money.
Right, vulnerability.
Exactly. And Ali and Ashraf from 2015, which involve grooming a vulnerable victim, those cases upheld convictions. The courts seem to be saying that mere submission driven by desperate circumstances or by grooming isn't free choice consent under S.74.
So the complainant's vulnerability and the surrounding context are really crucial for assessing freedom and capacity under S.74. Let's look at a specific context that comes up a lot. Intoxication. How does that fit into S.74's definition?
Intoxication, particularly by alcohol, is a very frequent challenge for applying Section 74. As highlighted in the key case of Bree from 2007, the central question for a jury when someone is very drunk is whether they still had the capacity to consent and the freedom to make that choice.
Okay, so if someone is completely unconscious or totally unaware due to alcohol, they obviously lack capacity. That seems straightforward.
Right. No capacity, clearly no consent under S.74. Similarly, if they are so intoxicated they're unable to communicate their lack of consent, they might lack the freedom to choose or act on that choice. But, and this is the controversial bit, if they are just less inhibited due to alcohol, and they still choose to engage sexually, even if it's a choice they deeply regret later or wouldn't make when sober,
Yeah.
then a drunken consent is still consent. That's the phrase from Dougal in 2005, isn't it?
It is. The critical factor isn't the level of drunkenness itself, but its specific effect on that individual's capacity and freedom to choose at that particular moment. The jury direction approved in Conkey in 2013 is very helpful here.
How so?
It tells the jury they must consider the victim's state of consciousness and their capacity to make a choice. It acknowledges that even a dim and drunken awareness might mean there's no real capacity for a meaningful choice. You have to look at the individual's state at the time, not just assume consent because they weren't passed out. So even with alcohol, it comes back to that core S.74 test.
Yeah.
Did they have the capacity and freedom to make that choice? Okay. What about deception that doesn't fall under the conclusive presumptions in S.76?
Right.
Does that kind of deception prevent someone agreeing by choice under S.74?
Now this is probably one of the most debated and arguably most confusing areas of consent law currently. If the deception isn't about the nature or purpose of the act, or impersonating someone known personally, does it still mean the victim didn't truly agree by choice?
Like hiding an STI or lying about your job or feelings or something like that.
Exactly. In B 2006, the defendant concealed his HIV-positive status. The court held that this did not vitiate consent for the purposes of rape. The deception wasn't seen as relating to the physical act of intercourse itself. The court focused very narrowly on consent to the sexual act, not its potential consequences or the characteristics of the partner.
That feels quite counterintuitive again, doesn't it? Surely if someone would absolutely not have chosen to have sex had they known that crucial fact, their choice wasn't truly free.
It does highlight a potentially narrow interpretation. The courts have sometimes applied to choice under S.74 in these deception cases falling outside S.76. And this was really underscored by that quite puzzling case of R. Monica v. DPP in 2018.
That's the one involving the undercover police officer, yeah.
Yes. The victim consented to sex with someone she believed was a fellow political activist, but who was secretly an undercover police officer infiltrating the group. She stated she absolutely would not have consented had she known his true identity and purpose.
Seems like a fundamental deception.
You'd think so. Yet the court held her consent was not vitiated for the purposes of rape. They essentially said that deception as to identity doesn't generally negate consent unless it falls under the S.762B impersonation category, which it didn't, as he wasn't impersonating someone she knew personally, or involves other forms of pressure.
That seems really difficult to reconcile with cases like Kirk or Ali and Ashraf, where factors like vulnerability or the circumstances did seem capable of removing free choice under S.74.
Yeah.
It feels, well, inconsistent.
Many legal commentators agree it's a difficult decision to square with the plain language of freedom and capacity in S.74 and the reasoning in other vulnerability cases. It suggests a reluctance to broaden the scope of deception, vitiating consent beyond the very specific S.76 categories.
And then there was R.V. Lawrence in 2020 involving deception about having had a vasectomy. How did that play out?
In Lawrence, the Court of Appeal quashed the rape conviction. They ruled that the deception lying about being infertile was about the risks or consequences of the sexual act, potential pregnancy, STIs, etc., not about the physical performance or the nature or quality of the act itself.
So again, a very narrow focus on consent to the physical mechanics of intercourse rather than the broader context or reasons for agreeing.
It appears so. These cases B. Monica Lawrence really underline that despite the S.74 definition, determining precisely what counts as free choice when there's significant deception that falls outside the narrow S.76 categories is still a major point of contention and difficulty for the courts. The law is arguably still evolving here.
Absolutely. It's clearly not straightforward. Okay, finally, let's just return quickly to the mens rea, the mental element for rape. What does the prosecution have to prove about the defendant's state of mind regarding consent?
Right, the fault element. Under SOA 2003, Section 11C, the prosecution must prove the defendant did not reasonably believe the complainant consented.
Did not reasonably believe. That word reasonably is the absolute critical change from the old law, isn't it?
It is. It's a fundamental shift. Under the old law, stemming from the infamous Morgan case back in 1976, an honest belief in consent was enough for a defense, even if that belief was completely unreasonable, maybe based on drunken fantasy or prejudice.
Right, the honest belief defense.
The SOA 2003 completely swept that away. Now, the defendant's belief that there was consent must be objectively reasonable in all the circumstances. It's an objective test, not purely subjective.
How is that reasonableness judged then? What did the jury look at?
Section 1.2 tells us it's judged having regard to all the circumstances, importantly, including any steps D has taken to ascertain whether B consents. So did they actually try to check?
Exactly. The jury considers everything the defendant perceived, what they saw, what they heard. But crucially, did the defendant take any positive steps to check if the other person was actually consenting? Just assuming, or maybe shouting, "You're consenting, aren't you?" probably doesn't count as taking reasonable steps to ascertain consent. It's about genuine checking.
And the presumptions we talked about earlier, S.75 and F.76, they factor into this reasonable belief element too.
Yes, they do. If a Section 76 conclusive presumption applies, nature, purpose, deception, or impersonation known personally, then lack of reasonable belief is also conclusively presumed. The defendant cannot argue they reasonably believed in consent.
Okay.
If a Section 75 evidential presumption applies, violence, unconsciousness, drugging, etc., then lack of reasonable belief is evidentially presumed. This means it's presumed unless the defense offers plausible evidence to rebut that belief aspect too.
And if the defense offers plausible rebuttal evidence for S.75 regarding belief, then, just like with the consent element itself, the burden shifts back fully to the prosecution. They have to prove, considering all the evidence, that the defendant did not have a reasonable belief in consent in those specific circumstances. And again, as we saw with Ciccarelli, the judge can withdraw this issue from the jury if there's simply no evidence suggesting a reasonable person could possibly have believed there was consent in that situation.
And a belief based on delusion, like in B 2013, is just inherently unreasonable.
Precisely.
So, the key mens rea takeaway for rape under the SOA 2003 is the absence of a reasonable belief in consent, judged objectively considering all circumstances, including any steps the defendant took.
That's the core of it. Though it's maybe worth just quickly mentioning, the actus reus also requires intention regarding the penetration itself. There was a case, Arviel Gabay, which showed that if there was an honest and reasonable mistake about where penetration occurred, for example, genuinely believing they were penetrating the vagina during what started as consensual vaginal sex, but accidentally penetrating the anus, without realizing that specific mistake could potentially negate the intention required for penetration of that particular orifice, meaning it wouldn't be rape of the anus in that very specific scenario. It's about intending the specific penetration that occurred.
Okay, that's a useful clarification on intention regarding the physical act itself. Right, well, that brings us towards the end of this deep dive. We've covered quite a lot of ground. We looked at the physical requirements of rape under the SOA 2003, that crucial element of penile penetration, the continuing act principle from Kaitamaki, who can commit and who can be a victim.
And then we really broke down the critical issue of consent, stressing that procedural path you absolutely must follow. First, check the conclusive presumptions under S76, dealing with deception as to nature or purpose, thinking Williams, maybe contrasting Lineker, and impersonating someone known personally, like an Elbeke.
Then, if PACE.76 doesn't apply, moving to the evidential presumptions under S.75, covering those situations like violence, being asleep or unconscious, physical disability, or drugging. These create a presumption of no consent and no reasonable belief, but importantly, they can be rebutted with plausible evidence.
Exactly. And finally, when those presumptions don't apply or they get rebutted, the assessment falls back to the general definition of consent in Section 74, agreeing by choice with freedom and capacity. We saw how that definition is applied and sometimes, frankly, debated, especially in complex areas like intoxication, remembering Bree and Kamke, and those difficult deception cases outside S.76 like B, Monica, and Lawrence.
And we wrapped up with the mens rea, that vital requirement that the defendant did not reasonably believe the victim consented, which is a huge change from the old subjective Morgan rule. And that belief is judged objectively based on all the circumstances, including any steps taken to ascertain consent. Remember Ciccarelli on withdrawing the issue if belief is clearly unreasonable.
So, to help consolidate all of this for your exams, maybe take a moment after this to actively revisit those key questions that are often posed in your source materials. Can you precisely define the actus reus and mens rea of rape under the SOA 2003? Can you explain and clearly differentiate the S.76 and S.75 presumptions? Can you list their circumstances? Crucially, can you walk through the procedural steps of how they interact with S.74?
Yeah, and can you explain the meaning of consent under S.74 itself, freedom and capacity to choose, and discuss how it applies, or the difficulties in applying it in those tricky areas like intoxication or deception? And importantly, can you actually use the key cases we've mentioned, Katamaki, Williams, Elbakay, Bree, Olegboja, Kamke, B, Monica, Lawrence, Ciccarelli, to illustrate these specific points? Naming the case shows understanding.
Exactly. Using the cases is key.
Now, here's where it gets, I think, really interesting as a final thought. Despite the SOA 2003's detailed structure and all these attempts to clarify consent with definitions and presumptions, the case law, particularly around the edges of deception falling outside S.76, and how we interpret free choice when things like vulnerability, circumstance, or intoxication are involved, it clearly shows that establishing consent or its absence remains one of the most challenging, nuanced, and frequently litigated aspects of criminal law. The legal concept of consent, especially what constitutes genuine freedom and capacity to choose in the huge variety of human interactions, is still being shaped and debated by the courts. It's not static.
So keep engaging with these materials, really trying to connect the specific cases back to the legal principles and statutory sections, and always, always remember that procedural flow. S.76, S.75, .74.
This deep dive into the law of rape under the Sexual Offences Act 2003 was based on material kindly made available by the University of London and brought to you by Sinorbit Academy, Sri Lanka. Good luck with your studies, and most importantly, really best of luck with your exam.